Welcome to Professor Ortlieb's Bluebook podcast, a series of podcasts designed to teach 1L students the basics of legal citation using the Bluebook. Previously, we introduced short-form citation and some rules governing shortened case names. In this episode, we will round out our review of Rule 10.2.1 with an examination of subsections A, B, E, and F. You want to have a copy of your Bluebook with you while you watch this podcast. As a review, Rule 10.2.1 governs case names. It tells us how to abbreviate or shorten case names used in textual sentences. It also helps us with our case names in citation sentences because we apply all of 10.2.1 and 10.2.2 to our case names and citation sentences. For a summary of Rule 10.2.1 as applied to practitioners and you as a law student, remember to take a look at Blue Page's Rule B10. Rule 10.2.1a applies to actions and parties. Several of these rules will be a review, as we've already discussed some of these in passing. First, if a case is a consolidated matter, that is to say, two or more different cases that have been combined on appeal, you should use the first case name. Also remember that you should only use the first party listed on each side. Don't eliminate part of a partnership name, and don't eliminate relators such as ex-rel. We're going to discuss relators more in just a few minutes. Omit words that indicate multiple parties or alternate names for parties. So you'll want to cut things like et al., aka, for also known as, or DBA, for doing business as. We don't put those in these sites. Some cases are known as in rem cases. These are claims cases brought about objects, and the name of the case is the object or objects in question. For these in rem cases, name just the first item. For cases brought about real property, use the common street address without a city, state, or zip. So a case brought regarding the property taxes for P. Sherman's dental office would be 42 Wallaby Way, but we would cut the Sydney. Some cases are a single case with dual captioning. The dual captions can indicate both an adversarial name and a non-adversarial name. Cases arising out of bankruptcy, family law, and children's law can have this dual caption. If both types of names appear in the caption of the case, cite the adversarial name first. Then place the non-adversarial name in parentheses with the appropriate procedural phrase. If only one name appears, use that name. Take a look at this example of a dual caption case. This is a picture of the caption that you might see in the West Reporter. This is different from a consolidated case where two or more separate cases were combined into one proceeding. This is a caption for a single case that has multiple names. Using 10.2.1a, you should get the following name for your answer. Note that the parentheses surrounding the non-adversarial name, in re India B, are not underlined. Rule 10.2.1b tells us more about procedural phrases. Ex-rel is the procedural phrase you should use when your case caption includes phrases such as on relation of, for the use of, or on behalf of. In re is the procedural phrase you should use when your case caption includes the on the matter of, petition of, or application of. You'll substitute any one of these phrases for ex-rel or in re. Remember to omit all procedural phrases except for the first one listed. Other cases come with descriptive or introductory phrases such as estate of, will of, or accounting of. You'll want to retain those. Procedural phrases should always be underlined, or if you are italicizing your case names, italicized. Rule 10.2.1e covers descriptive terms. Omit descriptive terms that describe a named party. These are terms like appellee, trustee, or executor, which further describe the party. In this first example, you can cut executor because the party's actual name is used. So the correct answer is Malfoy v. Potter. But you should retain such descriptive terms where the party is not specifically named. In this example, you would include trustees because the party's legal name is not used. In this second example, you see how the case name would look if the case were cited in the citation sentence, with trustees and school abbreviated according to Table T6. Last but not least, Rule 10.2.1f governs geographical terms found in case names. You will find that many cases, and criminal cases in particular, will caption a case with the people of the state of, or the commonwealth of, whatever the jurisdiction is, versus the defendant's name. When a case such as this is a state court decision, you should eliminate the name of the state and reduce the name to something like people or commonwealth, as you can see here. But when a case of this sort is from federal court, you should eliminate the term like people or commonwealth and retain just the name of the state, as you can see here. You get to omit phrases like city of and similar expressions unless the expression begins the case name. Omit all prepositional phrases of location not following city or like expressions unless the omission would leave only one word in the party name. You can also retain the prepositional phrase of location if it is part of the party's formal name. For example, you wouldn't write Juvenile Detention Center of Cook County, but instead Juvenile Detention Center. Always retain designations of national or larger geographic areas except in union names. Also retain any geography not introduced by a preposition. Now let's move on to some practice questions. As always, pause the podcast while you craft your answer and restart when you're ready to check your work. For all of these practice questions, assume that your citation is appearing in a citation sentence in an ordinary memo. This first question was testing your ability to practice citing a consolidated case under 10.2.1a. You should cite to the first case in the consolidated matter. Further, you need to provide only the first listed party on each side. Therefore, Jerry Gladstone is an individual, so the first party becomes Gladstone. Because we have this party's formal name, we can cut out the descriptors like trustees. On the other party's side, you have multiple people listed. You should list only the first person. Here, Harper. The answer, therefore, is Gladstone v. Harper. Notice that I ended the case name with a comma, and the comma is not underlined. Here's your next question. Note, this is a state case in a state court. This question tested your ability to apply 10.2.1's rules for citing a dual-named case. This is a case with both an adversarial and non-adversarial name. I know that I need to begin with the adversarial name. I can also see that this is one of those cases that involves a common party, like the people of the state of. Since this is a state case in the state court, I can drop the geographic prepositional phrase and cut this first party's name down to people. The other party is simply a private person, so I use just the last name, Stanley. Next comes my non-adversarial name. The procedural phrase used here is shortened to in re, and I retain the remainder of this party's name. I don't reduce it to simply H because I don't have a full last name. In re Charlene H is the full second name. Again, note that the parentheses here are not underlined, and if I were using italics instead of underscore, I would not italicize the parentheses. Let's try another state case question. Let's see how you did. This question had you practice using relators. In this case, you need to retain Stanley and Charlene H., as this is a case where Stanley is acting as a next friend to Charlene H. 10.2.1b tells us to change next friend phrase to ex-rel. On the other side of the versus, we have the governor of the state of Illinois. Under 10.2.1f, we get to eliminate of the state. Because this is a citation sentence and Illinois isn't the only word left on the one side of the parties, I need to abbreviate it according to T10, generating ill. Let's try one last case. Let's see how you did. In this example, we had a state party in a federal case. Under 10.2.1f, when we have a state of type party in federal court, we drop the state of part of the name and retain the jurisdiction instead. Because Illinois is the entire party's name, I can't abbreviate it under 10.2.2. Therefore, the final answer here is Stanley v. Illinois. Had this been a state court decision, the case name would be Stanley v. State. But I use Illinois because, again, this is a federal matter. You have now completed Lesson 5. If you have any questions, please see me or your teaching assistant.